Justice of the Appellate District Court Department. Hear ye, hear ye, hear ye. All persons having business before this court for God name of the offense shall be heard.
Thank you. Please be seated. The first case for oral argument this morning is People versus Brian Kuat.
Thank you, Your Honor. I'm Charles Greenberg, and I'm representing Brian Kuat. The people have conceded the first point in the brief concerning whether the appeal itself has been waived, so I will go directly to the second point. Do you have any questions concerning the second point? But I would simply reiterate that at the very least, you should remand the matter to the Seneca County Court for a restitution hearing as to the amount of the restitution.
He didn't ask for a hearing, and he was offered the opportunity to take the plea with or withdraw, and he said, I'll take the plea with the restitution.
Well, that is correct. I mean, he did. The Seneca County Court did grant him the opportunity to withdraw the plea when the restitution issue was raised. My argument is that you can still reach the issue on the issue of justice jurisdiction that this court does have. So
We'll look at that.
Okay. Do you have any other questions?
Thank you.
You're welcome.
Good morning, Your Honors. Mark Sinkwitz for the People. The court has already acknowledged one of the points I attempted to make, so unless you have additional questions, I'd rely on my briefs.
Thank you.
Thank you.
People versus Rana Neri.
Good morning, Your Honors. Well, there's many issues in this case. I'd like to begin just by talking about my client, Rana Neri, who's presently serving a sentence of 23 years to life. As is often the case for those who end up in long-term abusive relationships, Rana suffered physical and sexual abuse throughout her life, unfortunately beginning when she was a child.
Okay, and we know all the facts, so if you can go straight to the legal arguments.
Yes, Your Honor. And I think some of these facts are relevant both to my point about extreme emotional disturbance and to about sentencing. And I do want to touch on sentencing briefly, because a sentencing reduction in this case would allow one thing, and that is the parole board to consider Ms. Neri's application at an earlier date. This is a woman whose crime stemmed from years of abuse, and I believe that she should have the opportunity to be rehabilitated. She is somebody who can be rehabilitated and should have the opportunity to show that she could re-enter society before she's 73 years old. A reduction in sentence from 23 years to life to 15 years to life would give Rana the opportunity, if the parole board were to agree, to re-enter society at the age of 65. And I would ask this court to consider that. Rana was the victim of significant abuse at the hands of Dennis Perks. And both the prosecution
Well, there's no question it was an abusive relationship, perhaps going both ways at a certain point in time.
Justice Nimoy, I believe the people's expert did testify that she felt that the abuse went both ways. But there were, I think, greater commonalities between both experts' testimony. They both agreed that Rana's account of the abuse was credible. They both credited that. They both agreed she was abused.
They also indicated that not as an insignificant factor in this is the alcoholism.
That's correct. The people's expert in particular noted that she felt that alcohol was a greater contributing factor to this event than the abuse was. Obviously, the defense expert felt that there was extreme emotional disturbance established by these facts. And I do note that both experts found...
But the jury didn't accept the extreme emotional disturbance defense.
And I would submit that that is against the weight of the evidence. And I think, particularly looking at the people's expert, Gretchen Foley's testimony, I think she's doing an interesting thing by taking intoxication and taking extreme emotional disturbance and putting them in two separate boxes. And I do think that there is interplay between these two factors. And I would particularly look at...
They are distinct defenses, though.
That is correct. But when we look at the second element or the second prong of extreme emotional disturbance, which is that the explanation or excuse for the disturbance is reasonable when viewed through the prism of external circumstances as perceived by the defendant. And that to me is where intoxication is relevant to this inquiry, because we need to be looking at how Rana was perceiving the situation as a highly intoxicated person. She was drinking 3 rocks glasses of gin in the morning and switching to vodka in the afternoon. There's alcohol bottles throughout the house when you look at the
And
photos.
we understand all that.
And so I think that the people's expert's conclusion is faulty, in my opinion, because it takes the consideration of intoxication out of the picture entirely. And what I ask this court to do is, as it marshals the facts and looks at all of the facts that came into this case, is to consider intoxication as it relates to extreme emotional disturbance.
Thank you.
I would briefly just like to touch on the ineffective assistance of counsel argument. This was not a case where it
You
was...
have 5 different reasons you believe it's ineffective.
Yes, Your Honor. And one of those reasons is with the opening statement. It was not disputed in this case that Rana shot Dennis. It was disputed really whether this was extreme emotional disturbance or whether she was intoxicated. There was a complete defense and a partial defense. And when you read the opening statement, her attorney gives the jury no roadmap to follow. He does not talk about the elements of those defenses. And he already has hired an expert, so he knows he's pursuing the extreme emotional
But
disturbance
he did
defense.
say much of it on EED or intoxication had been addressed during jury selection, and we don't know how far they got into that during the selection process. So it's not like he just ignored the issues. He did say, as you heard during jury selection.
And I would just ask this court to read that opening statement, and where extreme emotional disturbance is truly the disputed issue at trial, his comments on it were extremely thin and actually quite confusing. He makes it seem like it's not going to be an issue in a paragraph that I quote in my brief. And that is one of the 5 reasons. And I would also touch on the failure to move to suppress. That is also there was the topic of motion practice in this appeal too. There is a colorable basis to move to suppress, and that is apparent simply from looking at these photographs, the people's exhibits. It is clear simply from the photographs that the police who are conducting the search are manipulating her computer, scrolling up and down on a conversation, and therefore conducting a search of the contents of the
Could it
computer.
have been a strategic decision by defense counsel, since she didn't remember the events leading up to the event, or purported that she couldn't remember? At least he got the statement showing, it wasn't just this, it's thought through. She's talking about the abuse, the other things supporting her testimony. And he did refer to that. Look at the Facebook comments to see what history was involved here. Perhaps that was a strategic decision.
Justice Niemeyer, I don't think this can be considered a strategic decision, because when you go to page 719 of the trial transcript, her attorney is working very hard to bar these pictures and this evidence from coming in. He's making what is a meritless hearsay objection to them. They're obviously party admissions, and there isn't a relevant hearsay admission, but he is fighting to keep these out. And the people appropriately at this time say, this is not the time for a Fourth Amendment objection. And I think he realizes at trial that these are a problem. He doesn't want them in, but he has failed to move to suppress. So I think it is clear he's regretting what he's done. It is not an intentional strategy choice.
I'm gonna look at that very carefully.
Thank you, Your Honors.
Morning, Your Honors. Caitlin Porter on behalf of the people. I'm just going to touch on 2 points. It seems that the panel has a good grasp of the issues, but I would just like to clarify the intoxication point and its relation to the EED. I would ask this court to reject defendant's position that intoxication should be used to buttress an otherwise incomplete EED defense. Obviously, it would be much easier for a defendant to prove that they were acting under the subjective disturbance if they were intoxicated, and the only way to view the intoxication's relevance to this is, as Justice Peredato pointed out, 2 completely separate defenses. They operate in 2 different ways. Intoxication serves to negate intent, while EED can only serve to mitigate an otherwise culpable defendant's responsibility. So I would just ask the court to reject that intoxication can be viewed in terms of the EED defense. I'll also touch on the search warrant issue. So defendant's initial brief refers repeatedly to the photographs of the messages from defendant as conducted through a warrantless search.
But there was a search warrant.
There was numerous search warrants in this case, Justice Smith. So the search warrants that were issued were referenced multiple times throughout the testimony. That alone is enough to defeat an ineffective assistance claim for not challenging a warrantless search where there was a warrant. And also, as Justice Nemori pointed out as well, there could be strategic decisions for not not seeking to preclude those warrants. I believe the expert relied on those warrants the defendant's expert relied on those warrants in their testimony to show defendant's suicidal ideations. So it was also used by the defense strategically. Unless the panel has any further questions for me, I'll rest on my papers.
Thank you. People versus Carlos David.
Good morning, Your Honors. May I ask for argument, or
Pardon me?
is it permissible to remove my mask for oral argument?
Sure.
Thank you, Your Honors. Good morning, may it please the Court. Guy Talley on behalf of Defendant Appellant Carlos David. First, I'd like to start out by saying, in light of some transcripts that came out after initial transcripts were released, we are hereby withdrawing our point 1 argument regarding the ORAMA violation. Next, I'd like to address briefly a couple of our other arguments. First is court's error in failing to grant the motion to suppress based on the people's failure to prove the validity of the inventory search.
Well, there's no question the stop was appropriate.
We don't have anything in the record to challenge the grounds for the stop, Your Honor. That's correct. However, we do think that the testimony and the evidence produced at the hearing as a whole shows that this was clearly a pretextual inventory search, which the Court of Appeals has obviously said.
They are permitted to tow because he was in a no parking zone, correct? And there was nobody there that could drive the car.
Both of those things, Your Honor, we're not challenging. He was the sole occupant of the vehicle, and there's no grounds to challenge that the car was in an area of the street where it should not have been left there. However, the problem here is that they did not follow their own protocol in terms of determining whether to tow.
In the brief, it says that they were required to call somebody else, but that's not really the hearing testimony, correct? It says you should consider, as opposed to the brief which says something along the lines of can only take place upon contacting somebody else. But so it's not. This is not required. That is, trying to contact somebody else is not required under case law. In fact, the case law is to the contrary, and it's not specifically required by the general orders, correct?
Addressing the general order, first, I don't believe that is correct. I disagree with that. The general order was read into the record during the testimony at page 30 of the hearing trial transcript, and I will quote here. It says, when deciding whether to tow a vehicle for safekeeping, members will, it's mandatory, it doesn't say may or can, it says members will take into consideration the crime rate in the area and the proximity of the operators/owner's residence, valuables in the vehicle, whether or not another person is readily available who can operate the car. So that's again, once page 30 of the hearing transcript.
You equate that to a requirement?
Yes, I do, Your Honor, I do.
Well, I believe what you just read, though, is that it said they are required to take that into consideration.
That's true, they're required to take it into consideration, but here the hearing testimony is unequivocally that they didn't even take it into consideration. I mean, he didn't even ask my client, where is this address? Is there someone available who can come and drive the car for you to take it away? And
We'll look at that very carefully.
Okay, I think it's also important to note that he was being arrested for a violation. He didn't even commit a crime, so his expectation was not very low. His expectation that he wouldn't be subject to intrusion was not lowered very much by having a valid owner's permit and just not having another person in the car. So, and we do think in that point, Your Honor, Gomez is dispositive on that, the Court of Appeals decision. The case law, Your Honor, I think is distinguishable as well. It doesn't say that they never in any circumstances have to do anything because those cases don't happen. All right, thank you, Your Honor. The next point I'd like to briefly address is the denial of the motion to eliminate an introduction of the evidence concerning the cash in the car.
Is it your position, sir, that the cash was irrelevant, or that it was relevant but highly prejudicial?
It's both, but more the latter, Your Honor. I think, as pointed out in our brief, it's not really relevant to the issue of criminal possession of a weapon. However, I think even if you can concede, for the purpose of argument, that it's relevant on the issue of knowledge.
The relevancy is the unlikelihood that someone else would have left that amount of money in the vehicle, right?
That's the people's argument, Your Honor, correct, yeah. And even if you could concede that.
And that decision by the court is a matter of discretion that we have to look at.
It is. The court didn't put any such rationale on the second part of the argument. The probative value of this evidence is highly minimal. I mean, but its prejudicial value is extreme. I mean, it's really in the nature of prior uncharged crime evidence. That's the reason why they put this in. There's no reason to, they had other evidence to show, that people wouldn't leave guns in their car, people wouldn't leave other things in the car that were his. But I think the prejudicial value of this is so extreme. That's the clearly nature of it, is to say, oh, he was committing other crimes.
And we'll look at that.
And the court did not analyze that at all. Thank you, guys.
Thank you.
Good morning. Briefly, it's our position there's no basis to disturb the credibility assessments made by the hearing court in this case. With regard to the cash, the sole theory of the defense was, look, not my car, everybody uses it. And again, our theory was that it's very relevant. It goes to link the defendant to the guns. Absent any questions, I'll rely on my brief.
Thank you. People versus Jose Molina.
May it please the court, Bridget Field on behalf of Mr. Molina. I would rest on my brief unless the court has any questions.
Thank you.
Good morning, Your Honors. Marty McCarthy for the people. If the court doesn't have any questions, I will do the same.
Thank you. People versus Jamal Young.
Good morning, Your Honors. May it please the court. Jeremy Schwartz for Jamal Young. Obviously, my argument focuses on the sufficiency and weight of the evidence, so I'm not going to belabor the factual points. Obviously, the court is familiar with those, but I suffice it to say there's no evidence that Mr. Young ever was in a position to visually see the firearm, of which he was convicted as an accessory. There's certainly no evidence that he ever possessed it. Before the shooting that underlies the murder count that he was acquitted of, there's no evidence that he was told about a firearm or anything like that before the individual that got out of what I can see the people can prove was his van.
But didn't the defendant actually admit to the possession of the firearm by saying something that these charges won't stick? The cops have never found the gun?
A year after the incident, a year after the shooting, when he was arrested on the indictment, the officer testified that Mr. Young said, when Mr. Young asked, in response to him asking, what am I being charged with, the officer said murder and a gun. And the officer did testify that Mr. Young said they'll never find, or they never found that gun, something to that effect.
I mean, then it won't stick, they never found the gun.
Right. But that was, again, a year after the shooting happened, and it was also after the police had they didn't arrest him. He was arrested on a parole violation, and in association with that, the police and homicide questioned him for approximately an hour. That's all on video, and that was introduced into evidence.
On video shows the minivan being driven by your client is following the victim's car. It parks, the shooter gets out, goes, fires 5 shots, runs back, and leaves the scene in the minivan. And then it's shown on a video within a half hour later, the two of them together at the mall, the driver and
So that's why
the
this.
shooter.
Oh, I'm sorry, Judge.
No, that's
That's why this case is much more analogous to the this court's opinion in Park, which is about a 30-year-old opinion, but it's more analogous to a situation like in Park where the driver of the car was acting suspicious, pulled up to a house, let an individual out of the car, pulled around the corner in what could be, the jury could have easily found as some sort of surreptitious, secretive way, let the person out who conducted a drug deal. Now, obviously, this isn't a murder, it was a drug deal, but conducted a drug deal. The driver came back and sped away. So very similarly to Park, the actions of Mr. Young could be seen as suspicious in some way, but as this court found, that the driver of the car could not be found guilty of accessory as possession of the controlled substances that were sold in that case. Mr. Young cannot be found as an accessory to the gun. There's, again, no evidence.
We'll look at that really carefully.
And I do just briefly want to touch on the people's implication that the court apply the mercy function of the jury to the analysis here. First, I did not argue that the verdict is repugnant. And obviously the Court of Appeals has recognized a mercy function, but I think this court would be remiss to extend that to cases where repugnancy is not an issue. The only reason I argued that is because in Williams, this court recently found that a person can be an accessory to a firearm, but not the jury. The jury in that case did find that defendant guilty of murder as well, but I'm not saying that because he wasn't found guilty of murder, this court can't do that. The reason why the court shouldn't do that is because in Williams, this court found that the murder charge was sufficient. Obviously, the court has no cause to do that here because there was no murder charge with respect to this defendant. So to extend the mercy rule with respect to that would be delving way too much into speculation as what the jury was thinking, and nothing further. Okay, unless the court has any questions.
Thank you.
Thank you.
May it please the court. Michael Hillary appearing for the people. I would just underscore what Judge Bannister and Judge Niemoyer already pointed out, which basically establish in this case the existence of a community of purpose. Clearly, the defendant was at the scene along with the co-defendant Maston. Clearly, they had communications, upwards of 30 communications by cell phone in the 2 weeks leading up to the crime. Clearly, they were seen together at the Walden Galleria Mall within, say, 20 minutes of the crime. I would like to distinguish this case from the Parks case that Mr. Schwartz has raised before the court. I think the distinction lies in defendant's statements, which a rational fact finder was under no obligation to disregard. In addition to the statement that Judge Bannister already pointed out, that the gun charge won't stick, the defendant, when he was interviewed by the police initially, first denied knowing anything about the crime, then finally admitted to being in the area, then finally admitted to being at the gas station, but he didn't hear the shots, then finally admitted to picking up the co-defendant, but he didn't know him, and finally said, I'm going to go to jail, but I won't be a rat. So I think when you put all of those elements together, you have a sufficient case. Unless the court has any questions, I'll rest on the brief.
Thank you, but don't go anywhere. People versus Charles Tubbins.
Good morning. May it please the court. Nicholas DeFonso for Charles Tubbins. I'd like to focus my comments today on the suppression point. The suppression decision below was wrongly decided and should be reversed. The court made two findings. The first was that there was reasonable cause to issue citations for trespass in open container. And the second is that when Mr. Tubbins ran, there was probable cause to arrest him for obstructing governmental administration. But there was no probable cause for OGA. I'm just going to call that OGA from now on. Because, for two reasons. First is that OGA is an intentional crime. And on this record, there's no evidence of intent here to impede a governmental function. So the function here...
Well, he didn't even know he was going to be charged. So.
Exactly. He didn't know what the police were doing because the police never voiced what they were doing. They simply got out of the car, approached the group, Mr. Tubbins ran. That's the sequence of events.
They may have, correct me if I'm wrong, they may have kind of asked the group, what's going on, or what are you doing? There was a response, we're just drinking and smoking a little bit, and then he ran. Is that right? Is that kind of the sequence?
Well, if we just back it a little bit, what you said, someone else says we're just drinking and smoking.
Someone else said, right.
Then they get out of the car and approach the group.
Well, that's right.
Then Mr. Tubbins runs.
Right.
So
Right, the
there's
question
no-
was asked from the car.
Yes.
Right.
Yes. And he didn't run as soon as his compatriot made some arguable statements.
When he saw the officers approaching, he
That's when he
made some exclamation and ran.
Right, correct, I agree with that. And so he can't have interfered with a government function that he doesn't know about. That's the first problem, and it would be different, I think, you'd have a stronger argument for OGA if the officers had gotten out of the car and said, everybody stop, we're issuing you all tickets for trespass and open
Right, they
container."
didn't even say to stop. They just got out of the car.
Right, but even if that was the case, you'd still run into the second problem, which is that flight alone has not been held to constitute the interference contemplated by OGA. There always has to be something else. There's some sort of interference that's in part physical in nature, the Court of Appeals has said, and for whatever reason, for OGA, that interference is not met by just simply running away. And so then we get to the initial finding of the court is that there's reasonable cause to issue citations for trespass and open container. And that there was reasonable cause to issue citations does not necessarily entail that there was the authority to make an arrest. There's an interpretation of, well, that authority depends
Well, that's not,
on
and
whether...
that's not what the court said.
What was that?
The court didn't say that, to your point. The court said there's probable cause to issue the citations.
Correct, yes, I agree, yes. And it's important to know that the authority to make an arrest depends on whether the violations were committed in the presence of the officers. And there's an interpretation of the record that no violations were committed in the presence of the officers. And at the end of the day, the court only held that there was cause to issue citations. And so the suppression decision really rises and falls on the validity of an OGA arrest.
Big OGA.
Yes.
Thank you.
Please, the court. The people haven't drawn our line on the obstruction of governmental administration. The argument that the people raised focuses on probable cause for several offenses, including the trespass and the violation of the open container. There is some language in the court's decision that renders the matter a little bit ambiguous because the court said that the police had probable cause to issue a citation with respect. Yes. The trespass, however, and to Mr. DeFonzo's point, that the court may have reasoned that way, although it's not entirely clear, because maybe they didn't have probable cause to, in fact, arrest him for that. But to Mr. DeFonzo's point, the trespass was committed in the presence of the officers. They were there on the premises. They were sitting at a table in front of the premises.
But the court didn't base its decision on that point. The court based its decision with respect to probable cause on OGA.
It said as I recall the decision, Judge, and the court has the record, but as I recall the decision, the judge said that the police had probable cause with respect to, and the second part of that was, and probable cause to arrest as to the obstruction. That's my recollection of it, but I'll defer to the court on that. If that's true, if that reading is correct, then the court is acknowledging, it's crediting the testimony that the trespass was committed in their presence. They had probable cause to arrest on it, and they had probable cause as to the open container violation. So,
But it's not like the fleeing defendant knew what they were doing. They didn't announce, we're going to arrest you for trespass, and then he took off. He has no idea what the intent of the officer is.
That's a fair point. That's true. I would concede that point. So the question at the end of this, the question is, did the officers have probable cause to arrest with respect to the two violations, not with respect to the obstruction? And was the search lawfully incident to that arrest? I think the decision by the court lends itself to a finding that, yes, they had probable cause to arrest, at least as to the violation trespass. And if they did, then in fact to conduct the search incident to arrest that yielded the criminal proceeds.
Thank you.
Thank you.
In the matter of Logan PG,
Good morning, Your Honors. May it please the Court, my understanding is that appellant submitted on this matter Amanda Oren for the Monroe County Department of Human Services. This case seems fairly straightforward, and we would rest on our brief unless the Court has questions specifically for me.
thank you.
Good morning, Your Honors. Maureen Poland from the Legal Aid Society on behalf of the child. I, too, would rest on my brief unless the Court has questions, with just providing a brief update on the child who remains in foster care. I would note that as of this month, he's been in foster care for 4 years. He is in a pre-adoptive home and doing well and hopeful to be adopted soon. So I just wanted to provide that update to the Court. If there's no questions, I would rest on my brief.
Thank you.
Thank you.
In the matter of Tyshawn B., oh, sorry, that's submitted, excuse me. John Frederick Jr. versus Jennifer Heidemann.
Morning, Honors. Pleased to court. Paul Watkins on behalf of the appellant, John Frederick, who's present in court today. It's our position, as I said in my brief, there's not a sound and substantial basis in the record to support the court's finding that's in the best interest of the child to be in the custody of his mother with a long history of abuse she has, substance abuse, and problems that she had. She was in custody 3 months after the child was born. She stayed in custody through January of 2019. My client had sole custody, physical and legal, of the child. She was released on parole in January 2019. 2 months later, in family court, she refused to take a drug test, and the court took a negative inference from it. The most important part, though, is in September 2019, 8 months after she got released and not seeing her daughter for a year and a half, she deliberately violated her parole by being in a car with her sister, who she knew there was a warrant out for arrest.
She was hiding in the trunk. We understand that.
Excuse me, Honor?
She was hiding in her trunk. We
Yes.
understand that.
And more than that, Your Honor, there was a large amount of drugs found in the car, too. So
But the
the
court
argument
wasn't
is,
compelled, counsel, the court wasn't compelled to decide which parent is best. The issue that is here, is there a less fit parent? I don't think anybody's arguing that this is a great choice, but the court has to make a choice as to who is better fit or less fit. And the court, after listening to the witness, made some determination. Isn't that a credibility determination that we should defer to?
well, yes, Your Honor, but the issue is there a sound and substantial basis to support the court's finding? Now, in the court's written decision, it said that the mother had not violated parole. Technically, that's correct, but the issue is the mother testified she knew she was violating her parole. Whether she was arrested for it or not doesn't really make a difference. The fact is that she knew she was violating her parole. She knew that violation of parole could result in the fact that she's going to go to jail again and not see her daughter.
All right, but again, the judge heard all this.
Excuse me, Your Honor?
The judge heard all this.
The judge heard all that, Your Honor, but I'm just pointing out that in his decision, yes, he did hear all that, but that doesn't mean that this court accepts that point blank. You have the ability to go and make your own independent judgment based on the record. And I think it's clear that the mother, with her substance abuse problems and history and incarceration, just is not the parent, especially due to the fact that this custody agreement had been in effect for so long, since the child was 3 months old.
We understand all that, and we're going to look at it very, very carefully.
Excuse me, Honor?
We understand all that, and we will look at it very carefully.
Okay, I appreciate Your Honor. Other thing is, there was incidents of domestic violence, which, yes, did occur, but CPS did an investigation, did not indicate it, and there's no testimony that the child was affected by it. Also, I'd like to point out that the court, in its decision, relied on testimony concerning my client's other daughter. And the problem with that is twofold. Number one, as you go through the record, you can see that the judge sustained hearsay objections to testimony from the mother or the other daughter about my client's interaction with the other daughter, plus it's not relevant. Just because my client had a strained relationship with the mother of another child does not mean that somehow that reflects on his ability to parent his own daughter in this case. The mother of the other child, when asked about the relationship between my client and the child at issue, said she saw him once and everything looked to be okay. So there's just not a sound substantial basis in the record for the court to go ahead and decide that a long-standing custody arrangement should be modified. And if the court has any questions, I'll submit.
Thank you.
Thank you.
Good morning. May it please the court, Heidi Feinberg on behalf of the respondent mother, Jennifer Heidemann. It's nice to see you all in person.
We have to agree that the mother certainly is not the mother of the year, correct?
Absolutely. And our position is simple, Judge. The court had a sound and substantial basis to change this order based on the fact that there was a real need for change. The evidence showed that there was parental interference, there was an obstruction of mother's access to the child, there was an inability or an unwillingness to co-parent, there was a failure to facilitate meaningful contact between the mother and the child, and then you add on to that evidence that the child was present for more than one domestic violence incident and presumptive evidence that the father was using or selling prescription narcotics. Our second point there, not only was there a demonstration of a need for change, so yes, I agree with you that, I think this might very well have been a choice between bad and worse, right? Which happens a lot in family court.
And the judge had everything in front.
And in that regard, it's well established that it's up to the fact finder, the judge, these judges to determine, is in the best position to determine credibility. And then even if you consider that the trial court made errors with regard to the weight of the evidence or with regard to hearsay, those were harmless errors in light of the other proof. Custody is supposed to be a fluid concept.
So you'd like us to keep things the way they are?
Yes, Judge. I think unless you have more specific questions for me, we'll rely on our brief and the record on appeal, but I believe that the order needs to stand.
Thank you.
May it please the court. Good morning, Mary Beth Barnett, the attorney for Natalia, the child. I can report to her that she is currently living with her mother and grandmother. And the mother is following that portion of the order. This proceeding lasted for over 2 years. There were 12 petitions filed. The record shows that during the course of that proceeding, the mother had exhibited poor judgment in the beginning. I don't think there's any denying that. However, she did work with her treatment providers, her parole officers, who I think saw potential in her, and she improved over those 2 years. However, the record also shows that the father's interference with the mother's relationship with her daughter did not improve.
So you think the court got it right?
I think that in this case, the court got it right. And it is basically the fact that the court is the only person who was in a position to observe the dynamic that was really happening between the parents, the possibility that the father would negatively impact rather than foster the mother's relationship with the child.
Anything further?
Yes, I want to directly address, because my brief did, the allegation that there's not enough evidence concerning the father's relationship with his oldest child that's not hearsay. And I stand by my statement that you can see from the record that there is evidence that was not objected to as hearsay that shows that the father had a very troubling relationship with his oldest daughter. And that I also cited to in my brief on page 119 on their exhibits G, H, and F, which were submitted to the court and would show that the child and the father argue, that the child accuses the father of lying, that the father accuses all
We
the...
understand
Yeah.
that.
So then I'd just like to say that I think the mother is the parent most able to promote the relationship between Natalia and Brianna, because the father has a very strained, if non-existent relationship with her at this point.
Thank you. Michael P. versus Jonah Dombrowski.
Good morning, Your Honors. May it please the Court. Jamie Richards on behalf of Appellant. I'm here to appeal the lower court's decision to grant defendant's motion for summary judgment. It's our argument that the motion for summary judgment and the granting of the motion was premature. We had not yet had an opportunity to exchange paper discovery on this case.
No depositions had been done?
No, although we had submitted discovery demands, we never received a response. We followed up on that response, at which point they submitted the motion. So we would argue that it's premature. Further, I would argue that the only evidence in support of the motion for summary judgment was an affidavit signed by each defendant stating they don't own the dog. So
That's not dispositive. Own the dog, harboring the dog.
Harboring the dogs, I apologize, yes, Your Honor. That's correct, which I think causes issues of credibility. Again, we didn't have an opportunity to pose either of them either.
Right, so we need to have more. Okay. Thank you.
Thank you.
Jane Doe versus State of New York. Good morning.
Good morning. Chris Liberati Conants for the State of New York. Your Honors, the judgment of the Court of Claims should be reversed because the court improperly applied an ordinary negligence instead of a medical malpractice standard, and because the state's submission of a non-conclusory expert affidavit in opposition to summary judgment precluded the grant of summary judgment here.
So you're claiming the expert affidavits, in contrast with each other, create an issue of foreseeability?
They do. They create a couple of issues. One, they create a question of fact with respect to whether there was a breach of the standard of care, which this is a locked inpatient psychiatric unit, which is not within the common knowledge, within the common understanding, and which should require medical evidence to determine whether there was a departure from the standard of care. To go to foreseeability, foreseeability is important for two reasons, both because the hospital, of course, has a duty to protect claimant while she was in the unit. But the scope of that duty cannot be determined without reference to how dangerous Mr. Shanes was or was not, the attacker in this case.
That all goes to foreseeability.
Correct. Correct, whether it's proximate cause or whether it's the scope of the state's duty.
So I don't see a big difference as to whether it's ordinary negligence or medical malpractice. It's still a question of foreseeability, and the experts disagree based on his conduct, his history, and his statements as to what was foreseeable. Perhaps it was foreseeable he'd stick his hand in his pants or wave things around or do others, but there was no history of assaultive behavior in the past.
That's absolutely correct, and I slightly misunderstood your first question. Whether the court views this in light of an ordinary negligence standard or a medical malpractice standard, there is a question of fact with respect to foreseeability. Further on the point of the medical malpractice standard, the level of supervision an individual requires in a hospital setting.
But she's not bringing a medical malpractice action saying that she wasn't treated properly. She said she was, a resident in the facility, and they hold her a duty to protect her under that standard.
They do, but what the appropriate level of care is, what the appropriate level of supervision within that psychiatric unit to keep her safe is a medical question. A psychiatric unit is in a unique place in which every individual who is on that unit is adjudged by a doctor to be dangerous to himself or herself or others. Not only that, but the behaviors that so troubled the Court of Claims in this case, and they are troubling behaviors, no doubt.
And they're certainly frequent.
And frequent, although front-loaded toward the beginning of Mr. Shanes' hospitalization. Those behaviors are symptoms of a psychiatric disease, and as such, they cannot be viewed as a matter of common sense, as a matter of course, this person was going to attack somebody.
So your argument, as I understand it, is that the hospital's duty to keep the patient reasonably safe inevitably involves considerations that involve medical judgment.
Correct.
That they're intertwined, and so that's why you say that it's really a medical, it's at least also a medical malpractice case.
Correct. The safety of claimants on the unit is a matter of medical judgment, because where somebody is placed, whether it's Mr. Shanes or somebody else, and what level of supervision they need is a medical judgment. And it's telling here that in claimant's motion for summary judgment, she submitted medical testimony alleging that the state breached its duty of care to her by violating the requisites, the applicable standards of care. And to move into my second point, the state in opposition submitted a non-conclusory affidavit in opposition to summary judgment. The Court of Claims' ruling that the affidavit in this case is conclusory goes against the cases in this area, in which generally a conclusory affidavit is one in which the medical expert opines essentially, I did not depart from the standard of care, period, signed the doctor. Here we have an affidavit that reviewed the same medical record as the claimant's expert and made specific rebuttals to the claimant's expert's opinion. The Court of Claims faulted the state's expert for not noting every instance of behavior that the court found troubling. However, the expert was not required to do that. What the state's expert did was look at this record and say, here is an individual whose symptoms have waxed and waned over the course of his hospitalization, as is common for a psychiatric patient. Not only that, there's no misbehavior in the record from June 21st to July 3rd.
We'll look at all that.
Excuse me?
We'll look at that. We have that in front of us.
Okay, thank you.
I have trouble, counsel, real quick about this whole duty idea. And maybe we don't even need to get there, because your argument has to do with questions of fact and foreseeability, as I understand it. But I'm a little concerned with if you argue medical malpractice vis-a-vis a duty between a patient and a physician, which under what the Pike standard is founded sort of almost in contractual principles, you're going to be expanding the duty of physicians and nurses to the patients in these facilities, where all you really probably want is a negligence standard. So do you really want a decision that says that medical malpractice, the duty between a physician or healthcare provider, applies in this situation? And we might not need to go that far, but what do you think?
we do want a medical malpractice standard to apply under these circumstances. I think the case law is clear that the level of supervision that an individual is held under in a hospital setting and what kind of protective measures need to be taken.
So the physicians and the medical providers in those facilities have a duty directly to that individual to exercise their best medical judgment for their protection from others. And are you sure you want to go that far?
I'm just trying to make sure I understand your question before as you press me on it.
Be careful what you wish for question.
Yes, so you're asking me whether the hospital owes a medical duty to...
No, the individual physicians and healthcare providers is really what I'm driving at. So I'm just exploring in case you had a view on that.
I would say that the level of supervision that person is held under is a medical question for medical providers.
Thank you.
Thank you, Your Honors.
Good morning. May it please the court. It's the claimant's position here that Judge Shaywee did get this case right, and she did get it right based on the facts. And the facts are this, that throughout Mr. Shane's visit at Upstate Medical, there were examples up and down how his behavior was not only words, but actions, right? So when somebody thrusts a knife, whether it be plastic or otherwise, at somebody, that's an
And he
action.
threatened to kill people, and perhaps if this was one where he had killed the person, I'd say he told you what he was going to do and he did it, and therefore you failed. Here, the issue is he raped or sexually assaulted your claimant. The issue is he had never physically been involved with assaultive behavior before. And there was no history of assaultive behavior.
Sexually
assaultive behavior.
I'd like to take you back to the affidavit that was submitted on behalf of Jane Doe. Jane Doe had only been there for a couple of days. And he comes out, exposes himself, touches his penis, and then says all these inappropriate sexual things to her. What they did here is they, to use the phrase, teed up this gentleman for this behavior. All you have to look at is their own words. Is the own medical records from Upstate, where on June 16th, and Judge Shaywee sets it forth, the team feared that if he was out of the hospital, his female ACT team staff and other females in the community would be at risk of sexual harm. How do we get around that statement by their own people? That is notice here. That is absolute notice that they were afraid of this individual from a sexual standpoint. That's sexual harm. That's what they are setting forth. That doesn't take into consideration the numerous other examples of Mr. Shane's acting sexually...
Mental health issues.
Acting sexually inappropriately with...
And that's why he was there.
Yes.
Yes.
That's right.
For mental health reasons in his activities.
Right.
And you're saying the mere fact that he's there is enough for liability against him?
No. I'm not saying that at all. What I am saying is his actions while he is there and their own words that the staff members and the community at large should be concerned about sexual harm from this individual.
They're demonstrating foreseeability in their own words.
Yes,
in those
absolutely.
medical records.
Absolutely. And it wasn't the only time that they did that. It was like when the security guard had to be brought in when the female nurse was giving him an injection because she was afraid for her safety. When the doctor had to be escorted from the floor.
So were these examples that we're just talking about now, were they noted by the defendant's doctor's report? You know,
Oh, yes.
His point was that, we had a non-conclusory report that listed all the actions or most of the actions or most of the important actions that would have given notice, and there was none.
Well, it was interesting in reading Judge Shawy's decision that they ignored that very note from June 16th about the sexual harm to the community.
So that was not in their doctor's
No.
report, their experts'
No,
report?
it was not.
Okay.
However,
So-
it was an exhibit to Dr. Wallach's report.
And that's your,
Yes.
Okay.
And that was the expert retained on behalf of the
that
claimant.
information, was it available to both experts?
Of course it was. The records were requested by us from Judge Shawy, and what Judge Shawy did is she did an in-camera review of Shane's records. And there were a number of pages, I want to say maybe 150 pages of records relative to Shane's, what she found relevant to the claims at hand, and she presented them to us. And those were the records that Dr. Wallach had, and those apparently were the records that the state's expert had. Although, if you review Judge Shawy's decision, she does specifically indicate that he didn't include these specific actions by Shane's or
So
their own statements.
They weren't just superfluous omissions of mentioning certain acts.
Well, Judge Shawy didn't believe that they were superfluous because she specifically set them forth in her decision that she found relevant as it related to foreseeability. And the foreseeability that this gentleman who was put in a room next to this vulnerable woman ultimately rapes her.
Foreseeability, it's an important element to both medical malpractice and a negligence standard, isn't it?
Yes, it is. And in this situation, so I've been doing this 35 years, doing this type of business. And I was always told that in order to render a conclusion or opinion, you had to have facts to back it up. It appears here that the doctor, on behalf of the state, either chose to or didn't set forth the facts to substantiate his positions.
Thank you.
Thank you.
Thomas Carcone versus James Noon.
Good morning, Justices. My name is David Longaret. I represent the appellant here, James Noon. This appeal concerns a conflict of interest of an attorney who is representing the differing interests.
Counselor?
Yes.
Your entire argument, as I understand it, is based on 1:7A, correct?
That is correct, Your Honor.
And that's a conflict of interest disqualification, correct?
Correct. Financial.
And that is solely with respect to current clients, correct?
That is correct.
Okay, what evidence is there in this record that, I think Mr. Noon, is it?
That is my client, yes.
Was at the time this litigation was commenced? Was at the time this litigation was commenced a client of Dunn with the law firm?
Mr. Noon's affidavit, I believe it's at pages in the record 120.
He says there's a belief.
He says, upon information and belief, and we were not provided any hearing, we're not offered a hearing through the Supreme Court judge to develop that record.
You didn't offer, I mean, if it was a client of the law firm of Mr. Dunn, your client would have a retainer agreement, would have some information about a specific case, would have some information that there's something pending. I've consulted, I've approached this lawyer. Your client provided absolutely nothing other than his belief, correct?
That's correct, and in contravention of that, Mr. Dunn and his firm did not provide any such retainer agreement saying that it was not.
You clearly have the burden. If you seek to deprive someone of their choice of counsel, which is a very serious right, even in a civil case.
Agreed.
When you go after that right and you don't provide anything other than your client's subjective belief, don't you think that is entirely insufficient?
I believe that creates the question, which would at least get you to a hearing to develop the record more on that. This is on a motion practice only, Judge.
Okay, we're gonna have to look at all those facts.
Okay, all right.
Thank you.
Thank you very much.
Osvaldo Garcia versus Town of Tonawanda.
morning, Your Honors. May it please the court, John Ryan on behalf of the plaintiff, Osvaldo Garcia.
Mr. Ryan, I'm going to interrupt you right away.
Please.
Okay. A long time ago, you asked for some records. And I think this court said, yes, we think you should get these records.
I'm not sure if the court actually said that, Your Honor. Let's say that there was a professional learning experience on my behalf with some procedural issues here. Ultimately, what happened with the original...
I think summary judgment was granted before we issued a decision, right?
It wasn't that simple, but essentially, yes, Your Honor, because there wasn't a formal order, so then it shouldn't have been subsumed, and then we came back up, and then we found out that the order wasn't formal, and then we had to refile another order, which would have subsumed the prior discovery order.
Well, my question was going to be a simple one. Would those documents that you asked for, would they have been helpful or possibly helpful to you in determining whether you have a defense to this, situation here?
Absolutely, Your Honor. Your Honor, the documents, the theory of liability in this case is a failure to maintain a signpost. During discovery, during depositions, we find out that there's a global sign inventory as well as repair records that the town who is responsible for maintaining the signpost has. So if there are records about the ultimate issue of liability in this case, they have to be material to the case.
Well, so let's get to the motion, though. We've got the motions that were made by the town and the county. Why don't you address the town? Basically, the question is whether the two defendants established their entitlement to summary judgment by submitting evidence of the lack of prior written notice, right?
Yes, Your Honor. I think the first thing that we need to look at for this is the first thing that they need to establish with their burden is that their prior written notice statutes apply to this matter.
Did they provide an affidavit from the town clerk or the town superintendent of highways with respect to written notice?
With respect to the town, Your Honor, they did not. Additionally, the reliance upon the depositions, in the depositions, there's no testimony that they went and reviewed those records as well. I think that there's the Hume case as well as the DeLong case that address that directly, excuse me. What I would like to discuss is this issue with the prior written notice statutes themselves. As I put in my papers, General Municipal Law 50E subsection 4 says what the prior written notice statutes can encompass, and in that has nothing to do with signs. This court specifically has adopted that analysis in the cases of Hughes and Taylor, which were both in 1996, and I cited those in my brief. Basically, it's incredible. This is our third time up here, and I'm still learning new things, different arguments that I want for this case. And when I'm looking at this case, I look at the Hughes case, which involves a tree branch that fell onto someone while coming across the sidewalk, okay? And the argument is very similar in this, that our statute, our prior written notice statute, can eliminate responsibility for trees. This court says no, and they rely on 50E4. Just like the tree in that case, I'm arguing the sign in this case. Now, the secondary issue that we have here is the language regarding obstruction, okay? And I think that there's no doubt about it. If there were not maintenance issues with the signs, and that was not our theory of liability, if I was just sitting here saying, listen, town, you did not come and pick up this sign within 24 hours of it falling, you're responsible, absolutely obstruction, prior written notices involved. That's absolutely true. But with our theory of liability, it's that this failure to maintain the sign that is not encompassed in 50E4 is what actually caused this to happen. We have testimony that there was no maintenance of it for 12 to 13 years from their own employees. I would really like to see what's in those global sign inventory records as well as the repair records for this. Your Honors, if we have a situation where this was not property owned by municipalities, like let's say this is an amusement park and a sign fell in front of someone where they had not maintained it for 12 or 13 years, that's a really good case. The only issue here is the prior written notice part of this. And so, Your Honors, again, with the obstruction issue,
That is only one part of this. The original theory of liability is the failure to maintain the actual sign itself, which is not encompassed in 50E4, cannot be encompassed in the prior written notice statutes. And because of that, the sign fell and created the second defect, which is the obstruction on the sidewalk. Thank you, Your Honors.
Good morning, Your Honors. May it please the court. I'm going to redesign my argument to address the issues that came up in the questions to Mr. Ryan. First, with regard to this discovery issue, the items that were requested, I don't see what impact they could possibly have on this motion for summary judgment. They're asking for the town of Tonawanda is a relatively large town. They want a list of the 12,500 signs. Merely listing what signs there are and where they're located, I don't see how in any way that could affect their claim that this particular sign was inadequately maintained. And secondly, they want a list of all of the repairs to all of the other signs. We provided the repair record for this particular sign, but if a stop sign fell down somewhere across town or the pole got bent and it was fixed, I just don't see how any of that information is in any way relevant. The trial court agreed. There's no expert who says he needs this information in order to assess the town's actions in this circumstance. And there's no credible argument regarding how this information, which of course we'll provide if the court requires us to, but how it could possibly affect the motion for summary judgment. Moving on to that issue, with regard to the prior written notice statute, courts have very clearly said that obstructions of sidewalks are covered by it. The town's... Yep.
Did you show that there had not been any prior written notice in this case?
I believe we have. There's the one case that mentions the town clerk, but we presented, in addition, I think 7 or 8 witnesses that were requested by plaintiff's counsel, and we didn't present the superintendent of highway, but we presented that person's top aide who was in charge of handling.
But did you present anybody who was able to come and say, we searched the records? And I can tell you based on a search of the records maintained by the town that we had no prior written notice. I don't think you did.
I don't think we did either. I don't think any of our witnesses were asked that question in depositions, and we didn't submit a separate affidavit from a town representative with. But this is a case concerning a screw that came out right before a sign fell down by all views of it. The idea that someone could have written...
But the basis of your motion was that you lacked prior written notice.
Well, but we presented all of the people who would have gotten that notice, and they said, we didn't get it.
We see these cases all the time, and routinely it's an affidavit or some type of testimony from the person who I've done a search of the records. Despite my valiant search to try to find it, I found nothing. So you haven't given us that, correct?
Correct.
Okay.
Anything further?
Yes, I also want to rely on the Abacola case, which I think clearly states that the plaintiff has the burden of proving that there is no prior written notice.
Not when you make this motion, not when you make a motion for summary judgment. That's your burden.
Okay, and lastly, to move on to the issue of negligence, even if prior written notice doesn't apply, there has to be, the plaintiff can't just come in and say you negligently maintained the sign. There has to be some basis for that. We have a sign that was not in need of any maintenance and didn't receive any maintenance for a period of time. It was by no means in a dangerous condition. If it had been, even without prior written notice, there would have to be some kind of notice to the town that it should have come and fixed this thing, but it wasn't broken. In all likelihood, it fell down right before the plaintiff came by on his bike. So even without prior written notice, I don't think there's any evidence to substantiate a negligence or premises liability claim in any event. Thank you.
Please the court, I'm Kenneth Kirby representing the County of Erie. I believe it's very telling that the plaintiff's attorney virtually mentioned the county not. The county did present an affidavit from the
And you did
indicating that a search was made and that no prior written notice was on record. We even went farther than that, and we had an affidavit, besides Mr. Geary's affidavit, an affidavit from Mr. Denning, who indicated that he had searched for any reports of a down sign, and he didn't find any. He was in the garage where if they get a call or something like that for repair. So the county is in a completely different position. The county established lack of prior written notice, which, having established it, the burden shifted to the plaintiff to demonstrate how it is that one of the two exceptions under Amabile, as refined by Yarborough, would excuse that. They didn't rely on the special benefit exception. To the extent they try to rely on this theory that somehow the county had, its contractor had created a dangerous condition of the sign by the manner, the U-channel method of attaching the base into the asphalt and then using anti-slip nuts and bolts. This sign, after it was put up, stood until 24 hours or less before the date of the accident. The plaintiff testified he saw it up the day before when he rode by on his bike. We even went back, based on the testimony of the town sign shop fabricator, that he went back the next day and reset the sign using the same signpost, the same base, the same anti-slip nuts and bolts. Mr. Nenza from the county went back 2.5, 3 years later, and it's in the record, photographs show that the sign remained standing for all of that time post-accident using the exact same methodology.
Yeah, I think we understand that.
So clearly, and the judge below pointed out, it's on page 14 of his decision, that he could not understand how a claim of needed discovery from the town should or could affect the county's entitlement to summary judgment where there was no further discovery demanded of the county by the plaintiff.
We understand that.
So basically, Your Honors, I would respectfully submit that the county of Erie, at a minimum, is entitled to an affirmance of the order below that granted its motion for summary judgment dismissing the complaint and any cross claims against it.
Thank you.
Thank you.
Philip Lake versus Structured Asset Funding, LLC.
Good morning, Your Honors. John Devendorf, Barclay Damon, on behalf of the appellant. We're respectfully asking the court to overturn the lower court decision and grant summary judgment. As Your Honors know from the papers before you, this case involves 3 separate final orders that were issued in Florida from structured settlement proceedings. As we have presented to the court, the claims in this case, respectfully, cannot be adjudicated without getting at the jurisdictional predicate. And the jurisdictional predicate was found in each of the successive Florida proceedings, year after year. We're not talking about one proceeding. We're talking about 2014, 2015, 2016. The 2016 proceeding occurred after the Florida statute was amended and Mr. Lape physically appeared in court in connection with that. We have presented to your honors a record that it contains stipulations, applications.
Let me just interrupt. So
Yeah.
in this case, the plaintiff alleges fraud in the sale of parts of his structured settlement. And it seems to me that Florida law permits a proceeding to challenge a judgment or order that's based on fraud.
Our understanding, though, is that that's a remedy that could have been sought in Florida that is now time barred. So we have a scenario here where the Florida courts determine not just that there was the jurisdictional predicate, that Mr. Lape was domiciled in Florida, but also that all aspects of
And
the
he said
Florida...
he was domiciled.
He absolutely said he was, Your Honor.
So he says one thing in a judicial proceeding. How can he say something different?
Exactly, which is one of our arguments. We have presented the full faith and credit clause, judicial estoppel, as well as the waiver and ratification theories, because this is a scenario where, respectfully, you cannot get at the claims that the plaintiff wants to bring without challenging the jurisdictional predicate that existed in Florida. Had he wanted to do that, he could have done it.
But if he had been fraudulently induced in Florida, Florida might not support those judgments. Isn't that the claim?
Well, Your Honor, that challenge wasn't brought, though. So in other words, that would be the
But it
forum.
could have been brought in Florida.
Could have been brought in
And
Florida.
you're saying it's time barred now, and therefore have to give full faith and credit to those judgments.
Correct, but not only full faith and credit because of that, but because there was actual substantive determinations that occurred in Florida on the very issue. And as Your Honor pointed out, this wasn't concluded in a vacuum. This was the plaintiff himself filling out applications in his handwriting reflecting his domicile. Having his driver's license, having, his... Yeah, all right. So absent any questions, we'll rely on our briefing.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Edward Stone, and I'm here on behalf of Philip Lape. Before I dive into some of the issues I've prepared, I just want to respond to a couple of comments that were made that are not accurate. A judgment that's procured by extrinsic fraud or fraud on the court can be challenged at any time. That's not before this court. What's before this court is a very simple determination, and that is whether or not the judge in the lower court abused her discretion by denying a motion for summary judgment before discovery.
And it seems like there's a huge lack of evidence on either side in this case.
No discovery has just begun. It was delayed because this first started with a motion to dismiss. That was denied. It then went to a motion to renew and re-argue. That was denied. Then there was a motion to summary judgment filed. That was denied, and so that was appealed, and that's where we are. The verified complaint in this matter alleges two substantive claims against the appellant here. One is for fraud, the other is for unfair business practices under New York General Business Law, Section 349. So it started off, and he's talking about the Florida orders as a starting point, but what really started this all off was in July of 2014, Mr. Devendorf's client filed a petition in Monroe County Supreme Court before the late Honorable Justice Bellini, and seeking to sell some periodic payments in Monroe County. Justice Bellini directed his client to serve an order to show cause on the Monroe Division of Social Services and the Monroe Child Support Enforcement Unit. That's in the record at page 23.
We know all the facts.
So they knew scrutiny was coming, so they devised a scheme, which we've carefully articulated in the complaint, to fake relocate him to Florida.
Here's what I'm confused about, Counsel.
Sure.
Do you need, in this case, with respect to your two theories, fraud and GBL, to set aside, void, vacate the judgments?
No,
right?
absolutely not, Your Honor.
As I read your complaint here, it looks to me like you're asserting a claim for damages based on those two causes of action or theory, right?
That's
you have
correct.
more than that in causes of action. That's your fundamental theory. And that theory will be governed by the economic loss rule down the road. So
Correct.
you'll have to prove, as I think you allege in your complaint, essentially, whatever the judgments were in Florida, you didn't get all the money you were supposed to get.
That's correct. That's correct.
And that's the fraud.
That's fraud, that's part of the fraud, and that the entire scheme was done to divest him of more of his periodic payments than he should have sold, and the way that it was done violated the New York Structured Settlement Protection Act and various other provisions of New York state law.
So assuming, just so I get it in my head fully, so assuming that the Florida courts did everything right, and you don't have to go down there to void their judgments or decrees, you still didn't get all the money you were entitled to?
That's correct.
Okay.
And then this, and what has been presented so far, that summary judgment should not be granted, correct?
And summary judgment should not be granted in this case. We have issues that we'll have to prove to the court. We're fully aware of
So on
that.
both sides, you need more.
That's correct. But in this
I think we
particular,
understand that.
okay. And the only thing I would point out, Your Honor, is that the New York Structured Settlement Protection Act, which is General Obligation Law 5-1701, 5-1709, was adopted to give greater protection to individuals negotiating to sell or transfer periodic payments. That's on page 15 of Respondent's brief, along with various different sites, including the Settlement Capital site and the J.G. Wentworth site. Mr. Lape, at the age of 4 years old, was seriously
So
injured
we know all that.
and brain damaged. And so that's what the SSPA was supposed to do. And with that, Your Honors, if there are no further questions, I'll rest on my brief.
Thank you. Antonella Ruth versus Elderwood and Amherst.
Morning, may it please the court. My name is Tim Hiller. I represent Antonella Ruth, who's the daughter of the decedent Lucia Consiglio. As your honors know, the issue here is whether the repeal of Article 30D should be made retroactive to cover conduct from March 3rd, 2020 to
You
April 6th.
agree that the presumption against retroactivity applies here?
No, I do not agree, Your Honor.
Why?
So if you look at the Regina Metropolitan decision, which is the
We have?
Yes, I'm sure you have. There's a threshold inquiry into whether this is the type of case where the presumption should apply, and that's where the court gets into the Landgraf factors. And basically, my reading of the case is what they're looking for is some sort of unfair, detrimental reliance on the statute that is then undercut by the repeal.
Well, it seems the question is whether retroactive application would increase a party, in this case the defendant's liability for past conduct. And here it seems that it would. It would expose them to state civil liability for conduct that occurred during a period when they had immunity.
So that's one of the Landgraf factors. There's two other Landgraf factors, and in Regina Metropolitan, they were dealing with conduct that was beyond challenge under prior law. And part of what I point out in my brief is that this is not conduct that was beyond challenge under prior law. If you assume all the facts in plaintiff's complaint are true, which we must on a motion to dismiss, it's not disputed by respondents in their brief that those would run afoul of federal regulations and subject them to federal regulatory action.
No, but even accepting that, they still are exposed to increased state civil liability with retroactive application of the repeal.
So I guess I would concede that their liability is increased, but I guess my point would be that this isn't the type of case where they fairly and justifiably relied on Article 30D. This isn't a situation where they acted fairly on Article 30D, and now all of a sudden, if I had known that negligent provision of stroke care and negligent provision of COVID care was wrong, I never would have done that. They knew the entire time that this was illegal behavior, and even under Article 30D, they weren't given blanket immunity. They were only given immunity so far as they acted in good faith. And so one of the points I raised in my brief is that, well, how can you rely on Article 30D to provide negligent stroke care, negligent COVID
Well, no,
related
no,
care.
they're not relying on it to provide negligent stroke care. They're relying on it to provide them with immunity in the event that they get sued for care that was given during a crisis, for a disease that, for a pandemic, for which the state was just overwhelmed.
So there's no doubt that their liability is increased. I'm not disputing that. What I'm saying is this is not a situation where they would have meaningfully changed their actions if they had known at the time that they would also be subject to state liability. I mean, they have the federal liability. They know they have to act in good faith, even under state law. This isn't a situation where they can say in any meaningful way, well, if I could go back in time, I would have done something differently.
Well, if all of that is true, then why didn't the legislature expressly provide for retroactivity? They certainly know how to.
So they know how to. The case law does not require that.
No, but it does require a clear expression of legislative purpose to justify the retroactive application. Where is that in this case?
Yes, so we have categories of what I would call positive evidence of legislative intent, which is from the sponsor's memorandum. They expressly state that the purpose of the bill, and I'm quoting here, is to hold healthcare facilities, administrators, and executives accountable for harms and damage that's incurred. I argue at length in my brief that, and it's unaddressed by respondents in their brief, that incurred is the obviously the past tense of incur. There's all sorts of cases I cite that without any further modification, the term incurred refers strictly to past conduct. So they're stating right there, this is our purpose. We want to hold these administrators and healthcare facilities accountable for what they've already done. The only way to effectuate that purpose is with retroactive application. They go on in that same sponsor's memorandum to state that they make all these findings about the extraordinary negligence that had happened. They say, as the COVID pandemic has progressed, it is now apparent that negligence by administrators and executives of nursing homes has occurred.
Again, we understand that.
Right, and what they say is that to date there has been zero accountability or transparency for these preventable deaths.
It seems to me that you could interpret that in a couple of different ways. You could say it's now apparent, and so now going forward, we're going to hold them accountable. We're now a year into this pandemic. Everybody knows a lot more, and now we're going to hold them accountable. And again, I have a hard time getting around the fact that there's nothing expressly stated in the repeal statute.
So,
and I agree with you, it's not necessarily required, but you've got to have a clear expression of intent.
Well, it doesn't get
We don't
any...
get to quote Judge Cardozo very often, but we can in this case, you know.
So, I mean, if you're looking for the clearest expression, that would be in the Kim affidavit, which was only made available after the briefing in this case was done. I know I submitted a motion to submit it as additional authority, and that was denied without prejudice to submit a post-argument motion. I mean, that affidavit from, again, the sponsor of the legislation expressly states the bill was intended to be retroactive. It's not just his secret intent. He also made that very clear in his floor debate.
In his floor debates, but the overwhelming other comments during the floor debates were against retroactivity. In fact, I think it was the chair of the health committee in the assembly said, you know, we are the legislature. We know how to make something retroactive. Mm-hmm. This is not going to be retroactive going forward.
So what I would say is that one of his interlocutors in that, and if you read it, I know you have read the floor debate, one of his interlocutors actually states that she's going to vote against the bill because the sponsor here is telling everyone in the chamber
they're afraid it might be retroactive.
that right. They believe it's retroactive, and the sponsor votes against it. And I've cited cases that say the individual statements of members during floor debates is generally not very persuasive evidence.
And I agree with all that, and I think that's our issue, is we've got to go through and, as you well know, and figure out whether it's retroactive or not. And we have all this in front of us, and we can look at it.
The other thing I would just like to point out quickly is the remedial nature of the statute, which I think is an important element of this. It's unmistakable. I know it's disputed by respondent, but if you look at the Black's Law Dictionary definition of remedial, and you look at this court's holdings on remedial statutes, this statute was designed to correct a wrong.
Even if we view it as remedial, that doesn't automatically.
That's correct.
Overcome what is a pretty strong presumption against retroactivity.
And that's correct, but what my argument in totality on legislative intent is the combination of the evidence that I previously discussed with the remedial nature of the statute, with the fact that we're talking about a statute that was controversial as soon as it was enacted. It was amended in August, right after it was enacted. Right. Then, less than 7 months later, it's repealed. The urgency with which the legislature acted to remediate this wrong, combined with the positive.
Wouldn't it perhaps been as urgent if they thought it had a retroactive effect?
Well, all I can say is this isn't just my argument. This is the argument that recently held the day, and I know it's obviously not binding on this court. It recently held the day in a recent published decision from the New York Supreme Court.
In Erie County?
No, not this case. This is a different case.
No, I know.
Okay,
no.
Yeah. Okay. So, and in that case, they held the combination of the positive evidence and the remedial nature of the statute, together with Mr. Kim's affidavit, was sufficient to show legislative intent.
And that's, once again, we will look at it all very carefully. Thank you.
Good morning, Your Honors. Todd Bushway on behalf of the defendant respondents. I think there's no dispute here that the Regina Metropolitan analysis applies, and the court set forth a 3-step. First of all, does it have a retroactive effect? And the big question there, does it have a substantive impact on a party's rights? It is clear that this impacts the defense. The Regina Metropolitan case, the court said, look, it's changing the effect of the impact of liability, what they're liable for, and therefore that's a substantial effect. If you reach that step and decide it would have a retroactive effect, the next step under the Landgraf and Regina Metropolitan is, can you overcome the presumption of retroactivity, or a presumption that it's prospective only? And you look to the language of the statute first, which here it's pretty clear, there is no language addressing it. And then you look to legislative intent. And it's not just a matter of legislative intent. The courts have held that means you look at whether the court or the legislator actually considered, affirmatively considered, is the language used, the impact of it. And here we have committee reports where they've honed down on the word incurred. I would submit to you that if you look at the rest of the committee reports, when it looks at the bottom of, under the title of justification, it talks about a much needed step to holding accountable and doing everything possible to prevent more deaths from happening. Forward-looking language.
Or at least equivocal language. I'm not.
Well, the doing everything possible.
But it's at least equivocal. Let me ask you a question. There were at least a statement from one legislator who seemed to say, we're going to let the courts decide. We're going to let the court decide if this is retroactive. Do you view that as an invitation for us to do a full-blown policy analysis of the issue?
The analysis under the second step of whether there's you can rebut the presumption that it's prospective only means you have to find affirmative language, an affirmative clear intent for it to be retroactive. If not, it's prospective. And the legislator in question...
We don't even get to
an interesting part...
An invitation of the legislature if we view there to be such invitation.
Right. The interesting part is the assemblyman you're speaking about, Judge, is Ronald Kim, the person behind all this, who says, but again, that has to be determined in court because it is not stated in writing in this particular piece of legislation during the discussion
we understand all that.
of whether this is going to be retroactive.
Which is contradictory to what he says in his affidavit.
Exactly. The last point I would make is the third part of the Regina Metropolitan Landgraf analysis is if you decide that the presumption is rebutted and it would apply retroactively, you then get to the due process consideration, which says you must have a legitimate legislative purpose affected by rational means. And what they are arguing here is that this is intended as a repeal to punish the nursing home facilities or hospitals for past conduct. And in Regina Metropolitan, the Court of Appeals specifically said the intent to punish for past conduct that's already occurred is not a legitimate purpose for due process concerns, which is clearly on point here if you get to that piece of the analysis. So unless there's any further questions.
Thank you very much.
Thank you.
The Jewish Home of Rochester versus the estate of Johannes Bachman.
Good morning. May it please the court. David Tang for the Jewish Home of Rochester.
I don't understand the math. Let me get right to it. And if I don't understand the math, I don't know how you get the liability, et cetera. So if I understand it correctly, the cost of being at this facility, at the nursing home, is approximately $144,000 a year.
It depends, Your Honor.
I thought that's what is in the record for this cost, the $399 per day.
So that is language that's in the agreement, and that would apply in the event that the resident is a private pay resident.
A what pay?
Private pay.
Which he was up until the time of his death.
That is not correct, Your Honor. There was a time when a Medicaid application was made, and the resident transitioned to Medicaid.
When was that?
I believe it was subsequent to the 2014 $88,000 transfer, 2015 or 16. And if you take a look at...
I thought he didn't qualify until after, or didn't start receiving payments until after he was deceased.
I thought there was a 7-month penalty.
There was a penalty. That's exactly, yes. Qualified for the benefit with the penalty.
Okay,
But never, sorry, go ahead.
No, you first, please.
So we never got past the penalty period. He died before the penalty period expired.
That's
Is
a
that
fair
right?
assessment,
Okay.
Judge Peridotto.
Okay. No, thank you. With that, so he entered the nursing home, what, in December of 12?
Paperwork was signed up, I believe, as early as November of 12, but yes,
Okay.
late 2012.
So he was there for 3.5 years in private pay status.
I believe that's right, 44 hours.
And if my number is correct, $144,000 a year times 3.5 years, doesn't that vastly exceed the $295,000 that he had on hand, the deceased, at the time he entered into your facility? And therefore, how is it that these defendants owe you anything?
I believe there was disclosure on a financial application that was in excess of 300-something thousand, Your Honor.
You're counting the life insurance, but the life insurance doesn't count for the nursing home. I mean, that passes outside the estate, as I understand it, and it was never cashed in. It was never forced to be cashed in as part of the deal. So I'm not so sure I buy into the idea that that's part of the equation at all. But even so, $144,000 a year, using that number based on what's in the record, times 3.5 years, it well exceeds $350,000, correct?
I believe the issue, Your Honor, is whether the resident would have qualified for Medicaid at an earlier date and time because of the transfers of assets. And that would have prevented the nursing home from being in such a upside-down situation financially in the last years of care.
But they're only upside down since 2015. Your bill starts in 2015. Somebody had to pay between 12 and 15. And no matter what, the math just doesn't add up for you, does it?
Well, Your Honor, I guess that we'd have to take into account, an increase in asset value. He's not paying the whole amount up front, the resident that is, for market fluctuation and things of that nature. But the idea of identifying assets and promising to use those assets, which I think is Your Honor's point, to pay for care, we are in a situation of transfers that have caused a financial penalty, a financial harm to the home because the Medicaid benefit didn't open.
You may have had financial harm, but how is it attributable to the defendant if all the 275 that was available to him through the deceased must have been used to do private pay, because otherwise you'd have been kicking him out, which you can't do, or you've been applying for Medicaid that much sooner.
Your Honor, I guess I'm doing some math on the fly, but I believe there's Social Security income that was coming in during the entirety of the period of his stay. So that's another 40-something thousand on top. I understand.
The math still doesn't look that favorable to you, does it? I mean, and if you don't provide us with the math, and you're the movement, how can we find liability?
I think the critical piece, Judge, comes to whether the language in the operating in the controlling contract that was signed by respondent case.
And that's the application agreement, not the long-term care agreement. The application agreement said, here's his assets, and I, as his representative, will use those assets to pay for his bill.
That's
You're
correct.
claiming they didn't, Mr. Case did not use all those assets. He transferred some of them to himself. But I thought he said he used them, even though he transferred to himself, to pay the bills.
I guess to the extent that that's disputed or a fact question, that would be at least one reason from Jewish Home's perspective as to why
Affirm the denial of summary judgment if there's a fact
why
question.
a 3212 question, yes, should not have been granted below.
So that would mean you would lose this appeal if we took it that way.
Not necessarily, Your Honor. Well, only with respect to, we are asking for reversal of the dismissal. If the court were to revive the contract question on 3212, I think the appellate would be satisfied with that piece of partial relief.
So you aren't even looking for necessarily judgment in your favor, it's just to keep going.
Well, arguably we would, Your Honor, with respect to the fraudulent conveyance action. And if I can touch on that for a moment, the debtor-creditor law contemplates setting aside of transfers in the event of a transferor having been rendered insolvent. If I can quote from the statute, a conveyance made by a person who is rendered insolvent is, quote, fraudulent to creditors without regard to actual intent if the conveyance is made or an obligation is incurred without fair consideration. And on this motion record, there is no dispute about transfers of assets without consideration. The statute...
The question is, did Mr. Case then use the assets transferred to him from Bachman to pay Bachman's bill at your facility? If they did, then it's not fraudulent anymore.
I guess, Your Honor, perhaps it's focusing on the 2014 transfer of the $88,600 that has left the resident in a situation where it cannot pay for its long-term care bill. The resident was receiving 24/7 care for, as Justice Curran pointed out, nearly 3.5, almost 4 years. But for this transfer, we would not be in a situation of, and the invoice is attached to the complaint in the record.
You're claiming £179.
And that's at the private pay rate. So it's an interesting math, because had there been a benefit that opened sooner, the facility would be prohibited from charging the private pay rate. It would charge a Medicaid rate. Now, it suffers from the situation where nursing homes lose on average $100 a day for Medicaid residents simply because the cost of long-term care is so high. And this is presented frequently in a situation like this, where there is an artificial impoverishment if there's a transfer of assets for the benefit of preserving things for inheritance, or transfer of otherwise to separate those from payment for the care.
Counselor, do you have in your hand, I can't get it quickly enough on my computer, but do you have the bill that was sent that starts somewhere in April 15? Can you tell me when that starts?
I have a copy of the invoice next to the complaint.
The basis of your claim is...
Record 35, yes.
Okay, well, how much, and when does that start?
This is for a portion of the time that the resident was at the facility, April of 2015.
So the amount that you allege is due commenced in April of 15, and the deceased had been there since December of 12, right? So
That is correct.
Okay. And did you think you established the math as a matter of law?
Your Honor, I think it's an interesting question with respect to the contract piece. The lower court, I guess, took issue with how the contract was signed. I think a careful review of the paperwork...
Okay, now you're really skirting his question, though. We understand those issues, but I'd like to hear the answer to Judge Kern's question.
Let me do a better job of answering. Could I trouble the court to repeat the question?
You're assuming I can remember it. Do you really think that you, given the questions we had, and maybe, don't let me bully you on this, I really want to know. Did you establish as a matter of law specifically how much was, that the defendant was owed you based on misappropriation? Did you establish that as a matter of law?
I believe the answer is yes, Judge. If there was an obligation, and we submit that there was by respondent case, to use funds to pay for care.
And how much is that?
Well, had those assets been used, we would not be in a situation.
This is a liquidated sum case, okay? This is a liquidated sum case. This is, you assume me on a promissory note, I owe X. So how much is X here?
$179,410.63.
But the diversion is only $85,000 is what you told us.
But the diversion is critical, Your Honor, as to whether the resident would qualify for Medicaid benefit that would not leave us in a situation where the facility is forced to bill for any penalty period or charge at private pay rates. Had the respondent done what the respondent contractually was obligated to do, which he did not, we would not have a penalty period, we would not have a balance of nearly $180,000.
Okay, I think we have that argument. Thank you.
On the fraudulent conveyance piece, Your Honors, we've cited a number of cases that inform how New York courts look to and evaluate a debtor-creditor 273 claim. There is, at least in my review of the briefing, little or no effort from the respondent to suggest that the controlling authority is not as briefed by the Jewish Home. The American Panel Tech case, the Second Department 2006, stands for the proposition that under debtor-creditor 273, a plaintiff is not required to show actual intent or a motive to defraud. The Stochastic case, 1993.
You should wrap it up because you're
The Stochastic case allows for recovery against the transferor who participates in a transfer of the debtor's assets. We've also cited this court's decision in Kaleida Health to support reversal of the dismissal of the fraudulent conveyance claim. We submit the court to rely on its precedent here in support of reversal on fraudulent conveyance. And finally, we've identified a Good Shepherd from the 2015 Third Department decision in support of the rule that when a transfer precedes a nursing home resident approval for Medicaid coverage. And I acknowledge that we didn't get past the penalty, but there was an approval subject to the penalty period. The transfer under Good Shepherd constitutes a fraudulent conveyance under 273. Like in Good Shepherd, the Jewish Home stated a claim for 273 relief. We're asking that the decision dismissing on that piece be reversed. Thank you.
Thank you.
Morning, Your Honors. John Bonavilla for the respondent case. I guess I could say I honestly don't understand their math either. And I've looked at this, and I think the lower court looked at it as well and couldn't make heads or tail of it. So I think their complaint mentioned something about the $88,000, their invoices, and you'll note the lower court was quick to point this out. They didn't invoice Mr. Case for over a year. Before then, they finally sent him a bill for, I think that one was for $179,000. And then I gather from their briefs that they're now looking for some insurance money that, as Your Honor correctly pointed out, that's a non-probate asset that passes outside of the estate. So I don't
There's
understand.
no question the cash value of that policy was listed on the application agreement.
That's correct. It was about $76,000.
Now, whether there's no question that your client, on behalf of Mr. Bachman, said, I will use Mr. Bachman's assets to pay for Mr. Bachman's care. He agreed to that.
Well, I think the lower court touched on that, Judge, and the specific language that the assets would be used for his care. Now, they're trying to dovetail that in, no, the assets would be used to pay the Jewish home. And I think the lower court is quick to point that out. That's not what that agreement says. And I think care can have a number of meanings. And I think Medicaid planning, which this was, and it was set up by...
It wasn't a very good Medicaid plan.
It's not a very
I don't disagree with you there, Judge. And I think, both parties would have been happy if the applications
And
had
there's
been.
no question in my mind
Yeah.
that Mr. Bachman had the right to leave whatever money didn't have to be paid in bills to Mr. Case. The question is, if Mr. Case took, and there's no question, he took money from the estate or transferred money from Mr. Bachman to him, his claim is that he used every bit of it to pay for his care at the facility. If that's true, then he's not liable for anything more.
Oh, I agree, Judge.
But if he kept some of the money, if he didn't use all the money that was transferred to him from the assets listed on the application agreement, doesn't he owe that?
No, because I think his affidavit is clear that everything that came to him from those transfers, from the Medicaid transfer, the Medicaid planning transfers, was paid over to the Jewish home.
But then he would know it. That was the part of my question. If you could show that everything he received from Mr. Bachman was paid for his care, then he doesn't owe anything. You agree with that?
I completely agree with that.
Okay. But if he's kept some money that was transferred to him that should have been used and was listed on that thing, he does owe that.
But they haven't shown that. And I think that's what. Oh, I'm sorry.
When you move for summary judgment, however, you have to demonstrate as a matter of law that you don't owe anything. So don't you think there's a question of fact as to whether or not, for example, that 80,000 plus in 14 was used not for the care of the deceased? So I'm having trouble with both sides getting summary judgment, I guess. So why isn't that a question of fact, sir?
Well, I think, and the lower court pointed this out in their decision, that 88,600 was the remedial, it was a deed of gift that the attorney that did the Medicaid planning had to do when he realized the first one was erroneous. And there's a result of those recalculations, that deed of gift had to be done, but Case had already paid back the original note less 88,600. That's why they had to do the deed of gift. So he didn't actually get 88,600, and his affidavit was quick to point that out.
Do you understand how when you have a lot of explaining to do, it sometimes results in a question of fact?
I don't think that's present here, Judge. I don't think that was.
I don't think we ever put that in the decision.
Yeah, I understand, but
I think we have that argument.
Yeah, I think the lower court, the decision was very well detailed in terms of going through these numbers and trying to figure out what happened, and I think they did that.
Thank you.
Beyond that, all I have to say is, and again, I want to reiterate, the plaintiffs or the appellants, arguments about this was fraud or whatnot, this was Medicaid planning. And I would surmise that probably the majority of their clientele are doing similar planning, and it's perfectly legal, but the attorney messed up in this case. So, but that was due no fault to my client. He's the one that has to clean up the mess here because the estate is insolvent.
Only to the extent that he has money from Mr. Bachman does he have to clean it up. If he's used everything he got from Mr. Bachman, he doesn't owe anything personally.
But again, I would push back on that and say, what if he got life insurance money after Mr. Bachman passed away?
I'm not specifically addressing the life insurance.
Okay.
I think we have your argument. Thank you.
I think that's it. With respect to the case law, I just want to say briefly, and this was heavily briefed. There is nothing in the admission agreement or the long-term care agreement that specifically says that the POA or the responsible party, whoever it is that's signing, is personally liable for any damages that may result or problems.
Absolutely.
That is nowhere in it, and that distinguishes this case from the case law that he cites, because that was present in all those agreements. So I don't see how you can have a power of attorney personally liable for anything when he didn't sign on to it. Not surprisingly, why would anyone sign an agreement like that? Thank you, Judge.
Thank you. Joseph S. versus State of New York.
May I please the court, Paul Watkins appearing for Appellant Joseph S. As I said in my brief, the one issue remaining now about whether my client suffered from a mental abnormality is not moot. Initially, the state...
Each and every annual review is subject.
Excuse me, Your Honor?
Each and every annual review of Article 10 is subject, and the fact that the year goes by doesn't make the appeal or the argument about whether in 2021 the finding was correct or not. Doesn't matter what they found in 2022 or thereafter. Your argument is whatever year in question is appropriately before the court.
That's exactly right, Your Honor. Each year is unique. Each year is the current year. Each year has testimony. Each year has a change of circumstances. And so, as you pointed out, my client has a right to an annual review, and if you don't have the right to appeal, then what's the point?
The statute says currently in section 10.09 about 3 times, so it's got to be current.
That's exactly right, Your Honor. It's the current, it's not the same issue. In fact, in this case, there's different testimony from my client's expert concerning his contact with the child who alleged the abuse. So that's exactly correct. Without the right to appeal, the whole issue of having my client being able to come back each year and ask for review is moot. What's the point of having it? So you're exactly right, Your Honor. Unless there's questions on that issue, I'll move on to something else. But it's clear to me my client has the right to continue with this appeal. Now, the next issue is getting to the main argument about the mental abnormality. The state noted there was a preservation issue, but as I pointed out in my brief, the court did, on its own, consider the issue and actually cited a case. And so, for want of a better word, it's self-preserved. If the court did consider it, it is preserved. Now, as to the actual mental abnormality claim, as my brief set out, the whole issue is there needs to be a finding that there was sexual abuse of my client's daughter outside of a 6-month period. And the only basis for that is, and I admit my client admitted that, but it was well after the event, and it was, he immediately retracted it. It was not under oath. I'd also note, as I put in my brief, that twice the state did a review to see if he should be civilly committed, and that never came up. So again, unless there's some questions, I believe it's clear, and Justice Denman, you're exactly right. My client's a right to review, he has a right to appeal, this should go forward, and when you move on to the mental abnormality, there was not sufficient credence for the hearsay for the court to rely on it. And there's just questions, I'll submit. Thank you.
Good morning, Your Honors. May it please the court, Kathleen Treasurer for the state. No one is saying that he doesn't have a right to appeal from an order determining he has a mental abnormality on annual review under 1009. The problem is that the order that he has appealed here has been superseded by a more current order. March 1st, 2022 order that finds that he still has a mental abnormality but can be civilly managed on cyst. And that...
Ms. Treasurer, here's the question I've got. If we were to find, for the sake of argument here, that there was no mental abnormality currently as of the time of the review, you wouldn't have been able to hold him any further. He'd have to be entitled to immediate release. So how is that not something we should review if he would be then entitled to immediate release?
Well, that's the but-for argument that the respondent is making on appeal, and there is no but-for test of mootness. The test of mootness is, does the order that's being appealed have any current legal effect between the parties? And this one does not, because it's been superseded by the March 1st, 2022 order. He got the fresh current...
The March 22 order says that as of this date, he has a mental abnormality. It doesn't say as of the date of the prior determination he had a mental abnormality. They're saying at what was presented then. It seems he's entitled to review as to the last one as to whether it was established there. If it wasn't established there, as Justice Kern said, he'd be out and there would be no retention.
And if he wanted to continue the appeal from that order, it was very simple what he could do, Your Honor. They do it all the time in Oneida County Supreme Court. The respondents ask the court to hold the annual review in abeyance pending the outcome of the appeal of the order of continuing mental abnormality or confinement. It's been done time and time again. This court in matter of Holmes recognized and endorsed that as a matter of keeping the appeal from going moot. But in any event, Your Honors, I will move on. I would just only say on the mootness point, if to find that this order is not moot is going to invite the respondents to appeal each and every order, and then it's going to be a little bit confusing if, per se, there was an appeal from the March 1st, 2022 order that got perfected before the other one. It's going to create, I think, a bit of confusion in the courts as to what is still extant and what is in effect.
Just as a practical matter, just wondering out loud, would the state be able to make a motion for that stay too?
We typically don't, Your Honor. I mean, I think because we are trying to, we never oppose it. We don't oppose the motions to stay the annual review in abeyance. We've let that go. We don't necessarily encourage it either because we are supposed to be holding them on a current finding of mental abnormality, not on something that's based upon what is a stale record by that point in time. In any event, the record here is sufficient to support Supreme Court's finding of mental abnormality. What the dispute comes down to is a dispute over the credibility of the two experts. Dr. Jenks credited the admissions that the respondent had made time and time again, that he had abused his 5-year-old daughter when he was out on parole in 1998, 2009. He made those admissions 3 times at the very least, once to his treatment provider and 2 and 3 times to his parole officers in response to the fact that he was having a deceptive polygraph when he was being questioned about his sexual offense history. There is no indication in the record to support his claim now that it was not him who abused his daughter, but the
So
mother.
you say if we decide to reach it, you win anyway?
Yes, we do, Your Honor.
I just want to make
That's
sure.
it. Yes, we are. We're arguing this is, again, the credibility of the experts, that the court properly credited our experts' testimony. The allegations that he admitted to are consistent with his past crimes of sexual abuse. And we would also point out, too, that he also had a pattern on the 2003 offense that he committed of accusing somebody else when he thought he himself was under suspicion of sexually abusing the child. In that case, he accused the neighbor boy of doing it, and he tried to point suspicion there. Here, he's clearly trying to point suspicion to the mother's ex-boyfriend. There's nothing in the record to really bear out that. For all these reasons, and including the fact that Dr. Jenks also considered the fact that there had been a collateral interview of the victim and her mother, she discounted those statements that they made. Again, the 5-year-old, who is now 16, just said she had no memory of abuse. Dr. Jenks said that's not unusual given her young age at the time, but it happened. And as for the mother, Dr. Jenks discredited that because she didn't think it was possible for the mother to be, to have that knowledge or awareness. She thought it was very doubtful. And she was relying on the fact, too, that in 2003, when he was awaiting charges of the qualifying offense, he offended against his niece when he was left alone with her in a 10-minute period. So for all those reasons, we think the order below should be affirmed if the appeal is not dismissed as moot. Thank you.
Canton Potsdam Hospital versus SAFE.
Good afternoon, now that it's in the afternoon. My name is Ben Wilkinson. May it please the court, I represent Canton Potsdam, members of the now defunct Honey Trust in this matter. So there are 2 appeals that are presently pending before the court.
Mr. Wilkinson, we know that the appeals, and you can have faith that we know the record well. You're arguing that the court should have granted your motion to vacate based on lack of jurisdiction and/or in the interest of substantial justice, right?
Yes.
Basically, and I don't want to steal your thunder here, but just so I've got it straight, that there was no notice, opportunity to be heard, therefore it's without jurisdiction. Also, the court granted dispositive relief, is your argument. As I understand it, and you're citing to Rosenblatt, which has a good discussion of the Toronto case, and Rosenblatt says, wait a second, when it's dispositive, the need for a notice and motion is all the more important, I suppose, is one theory. There's no authority in the written stipulation for this, because it does say an order, for example. It doesn't say without notice. It also provides for an end date to the stay of the litigation. It provides for an end date of the payments. Would you argue that having an end date for the payments is inconsistent with saying the court can extend it ad infinitum?
Well, what we would say in response to that is that the language that I think respondent has pointed to on the stipulation doesn't expressly and unambiguously authorize the no notice and the ability for the judge to unilaterally make that decision. I think really we'll admit that the stipulation may have not been as artfully crafted as it could have been. We're not denying that, but I don't think it clearly states that the court would be authorized to take the action that it did.
As I read this stipulated order, this agreement, the purpose of it was to see if the parties could get the benefit of this committee's advice, to see if they could work out a settlement, put everything on hold, give the trust something to work off of, that is, that they've got some money to continue to survive and not be taken over by the WCB. And once that failed, what was the point of having any further payments?
Right, well, that was the position that that the appellants attempted to take in the oral argument itself, that there was a sunset provision in the stipulation itself, because once the settlement discussions or attempts had been made and the committee had completed its work, that didn't go anywhere, so litigation needed to continue, and there would be no reason that our clients would be required to continue to pay in perpetuity into the escrow payment.
And they, at least many of them, at least your clients, objected to making any further payments against this $20 million assessment or whatever it is now, right? So
yes.
The idea that they have to continue making 75% during the litigation is almost saying, we're not sure if we owe you anything, but you got to keep paying.
Exactly, which in the interest of justice, we think was extremely inequitable.
Okay. Take us to the disgorgement thing. Here's my issue on the disgorgement. We don't have the $600,000 disgorgement issue before us. That ship has sailed, obviously, right?
Correct.
Based on the previous appeal. So as I understand it, you're complaining about the letter decision that came out, letter order, whatever you want to call it, from the Supreme Court authorizing $340,000 or $60,000 on the $400,000 request.
Correct.
My issue is, it looks to me like your clients basically agreed to having an informal letter motion kind of practice. There was no objection to the procedure. Unlike what we have here with sua sponte relief, grants dispositive relief on the continued payments, this strikes me, sir, as a little different. That is, you kind of agreed to, judge, go ahead and decide what letters are going to be fine.
I would characterize that slightly differently. We would have gladly engaged in motion practice, and I believe that our letter may have mentioned that.
But you didn't object. You didn't say, Judge, you can't do it this way. Unlike the oral argument, where your counsel clearly said, Judge, we'd like to be heard. No, you don't have to be heard. But
right.
This is, you went forward, you sort of charted your own course, didn't you?
It was in response to the informal nature of the request, because I believe the stipulation didn't necessarily require a formal motion, and so in order to create the best record possible, it was we chose the course of filing the letter in opposition, which clearly stated our position in opposition. So as Judge Curran very astutely pointed out, they summarized our position on the reasons for the reversal of the September 2019 order directing escrow payments. I just would like to also add to that the stipulation language itself, had a reservation of rights in it for our clients, which it really would never, our clients would never have consented to entering into a stipulation in which they would be required to make payments on their assessments, of which they're contesting in perpetuity. That's just incongruous to have those two that was not intended by the stipulation. And the other thing is that these escrow payments are the basis of this litigation. They say that we owe this, the Hunting Trust says we owe the we owe the assessment funds, and that in response, our clients have said, no, due to the fraud and the other breach of contractual obligations by the administrators of the trust, that they are the ones who are responsible for creating this assessment, and therefore there should be some sort of offset or damages in our favor. So to award those funds and then transfer them out, to award those funds by making us pay into the escrow account and then give those to the trust itself, that in and of itself is awarding a partial summary judgment.
Because for all you know, you might do even better if the WCB took it over.
That was also briefly touched on in that particular oral argument and kind of pushed aside.
Okay, I think we understand that.
Okay.
Thank you.
So, and then just briefly, on the third-party defendant's appeal of the order denying their motion to dismiss our third-party complaint, we take the position the lower court was well within its discretion in denying the threshold motion to dismiss. Our third-party complaint lays out in detail the manner in which the third-party defendants, Gina Emerson and Ed Alberts, who were the owners of SAFE, utilized SAFE to reap profits at the expense of the trust. And while I can anticipate that appellant on this particular appeal will point out the long time period in which the litigation started as to when the third-party complaint was filed, as we point out in our brief, the third-party complaint was based on information that was learned in the course of discovery in the underlying action, which admittedly has taken a very long time to wind its way through the court, multiple judges, a stay of discovery for the stipulation for the committee's work. And so after we learned that information through the depositions of Gina Emerson and Ed Alberts, that forced the third-party complaint.
Which led to the piercing the court of veil allegations, which you would say that on a motion to dismiss, you clearly have stated enough under the case law to meet the threshold to be allowed to continue on.
Correct. Yes, Your Honor.
Thank you.
Thanks.
May it please the court, John Houston Pope for the defendants on the initial appeal and for the third-party defendants on the concurrent appeal. On the initial appeal from the plaintiffs, the court clearly possessed jurisdiction to alter its own order. That's a stipulation and order.
According to your theory, the court could have woken up one day, taken the bench, and say, I'm doing this.
Absolutely. The court had that right because it was a stipulation and order, and in fact, when it was submitted to Justice Carol Lunis, she altered what the parties had stipulated to and added her own terms. She made it her own. Justice Parris picked it up and worked with it. All the due process that they complained about, they got in the motion to vacate procedure that is now the basis of this appeal. And Justice Curran, you said just a couple of years ago in a case, Braun versus Cesaro, in which you dissented, you said...
All alone, I might add.
Yeah, I know. I was disappointed in that. But you said that you can't appeal from an oral motion because CPLR says it has to be written, and it's important that we have that so there's a sufficient record and fairness for all parties when something comes up on appeal. There's a sufficient record and there's been fairness to all parties on this particular action. So the question is it...
So you're thinking a motion to vacate is a cure-all for any time a court does sua sponte relief that's dispositive in nature?
I think that it can serve as a cure-all and did in this instance, Your Honor. I'm not going to do it I'm not going to claim that for everything, but we do it in other instances. We use the motion to vacate as the way to deal with an appeal of a improperly entered default judgment. So we do it in a lot of various instances, and that's why it gets all the due process to which they're entitled. It's also the case that they did say to the court in the affirmation that they wanted relief that was just, fair, and proper, and this, I believe, relief is sufficiently related to what they were seeking.
Counsel, you may recall that in your motion to dismiss the appeal that we granted at least in part, you indicated that if the court agrees that there's nothing in the motion paper seeking this relief, then you should dismiss the appeal, and you got what you wanted.
That was the motion from the trustees, yes, Your Honor, but that was because of that was also because of the procedural posture, Your Honor, that they were appealing from a sua sponte order, and I thought that was what the court explained was its reason for this. That's certainly the reason why we saw the motion to vacate. So it was in the affirmation. It was the broad request for relief by the movement.
We've already decided that because you convinced us that it wasn't in there. Or the trustees did, whoever.
Yeah, the trustees did, Mr. Kukowski, who's a much better advocate than I am, Your Honor, but he's in Italy.
For my benefit, we should take the disgorgement thing. Do you think the parties charted their own course on the $360,000 with respect to the procedure?
No, Your Honor, because we had used, the procedure that was implemented for the $360,000 was ordered by Justice Paris himself when he took control of the escrow. Because in the stipulation, it required no court intervention and provided for no court intervention to transfer money that was in the escrow. It just simply had to reach a
I thought there was a
threshold.
provision that says you could approach the court informally if the parties agreed or something like that. The last paragraph or so.
Yeah, well, in the stipulation, you can approach the court to get an interpretation. But in the stipulation to transfer money from the escrow to the trust simply requires a letter that explains that you've reached the thresholds that the stipulation says is there, and that's it. There's no other process involved in it. There's opportunity for discussions of it. In one instance, we turned over all the information. In another instance, we didn't.
My question, Counsel, was that the other side didn't object to doing the $340,000 order on letters, correct?
They did not object to that, Your Honor, and it was an efficient and reasonable way to do it. So, overall, I know, Justice Curran, you were wondering whether or not it made any sense to continue the escrow and the payments into the escrow after the committee process was over. And I think that Justice Paris wisely decided that if the plaintiffs were going to insist on more court intervention into how the escrow was run and what was happening with it, he was going to follow their lead, intervene more, and that he was going to reinstate the obligation to pay because he felt, I think, the way I read the transcript is he felt that the parties were not being serious enough about moving the case along.
Well, how does that encourage your client to move the case along when all of a sudden you're getting paid?
No, we're not getting paid, Your Honor. There's money going into an escrow that if we convince the court can be released to take care of the obligation to the trust.
Well, Counsel,
We don't
I
get
think
paid.
the import of the question, as I understood it, was that it allows the trust to continue to survive and not be taken over by the WCB.
That's true, Your Honor. And being taken over by the WCB is a very bad thing for everybody, plaintiffs and all of the other members. There are another 80 to 100 members who are affected by takeover by the WCB, and that's who the trustees are trying to protect here, Your Honor.
Would you take me to the impleter argument? It's kind of a neat argument that you made. I'm not sure I agree or disagree, but in terms of the impleter, you said basically if the trust prevails against the members, the trust will have established its compliance with its contract and kind of implying that there's no breach of fiduciary duty. Therefore, there's no way that can be passed along to the individuals in the impleter. That's essentially your argument, if I understand.
I call it the self-extinguishing third-party complaint, Your Honor, because if those claims, which are asserted as defenses against the trust, are successful, there will never be a claim to hold over. Right. So if they're good, there's going to be zero against the third parties. If they are not good, it will have established that they have no value, that they have no, or they have a limited value that will be credited in the
in this
trust
record, we
case.
shouldn't look at the practicality, saying if the court was going to allow impleter, the court probably would have granted a late amendment to the complaint. But put that aside. With respect to the breach of the Pearson and Corporate Veil, you would say that under our case law, that third-party complaint does not allege the appropriate allegations, correct?
That does not come close, Your Honor. There is the most important point in the deficiency on veil piercing is that they do not link the purported domination and the violations of corporate formalities, which I don't think they even allege any proper corporate formality violations. They do not link those to the wrongs that they seek relief for, and that's required in it. The one other claim, the two other claims that I would just give you a sentence or so on is on common law indemnification. I believe that Genesee, Wyoming YMCA, this department has said that a breach of contract claim cannot be common law indemnification off to somebody else when you're guilty for it. And on the aiding and abetting, it has not been answered, and I think that it's absolutely fundamentally the rule throughout this state that if you are the person who is accused of creating the liability for a party, so you're the person at the company who did whatever it is that makes the company liable, you cannot be held as an aider or abetter because being the agent by which liability is created forecloses aiding and abetting. And I point out for you, for instance, the Hicks case, which was in the Southern District of New York, and I'll only do that because I won that case. But,
You're the primary actor, you're not the helper.
I'm sorry?
You're the primary actor, you're not the helper.
Exactly.
Okay.
And
I think we have
for the reason why there is a primary actor. If there are no other questions, Your Honor, I think we should all take lunch. And I'd just like to express my appreciation to the court staff for doing such a good job of taking care of the sanitation. That it's nice to see.
There you go.